We start in the highest court in the land. The Constitutional Court today said to hear a significant challenge against the constitutionality of a section of the Births and Deaths Registration Act amid concerns that these are discriminatory based on gender. The applicants are two married couples and they successfully contested this legislation in the Free State High Court. They demonstrated that the male spouses were unjustly barred from changing their surnames after marriage. One husband is seeking to adopt his wife's surname, while the other insists on hyphenating the surname to include hers. The existing system's refusal to allow men to take their wives' surnames is an infringement on their rights that, of course, need to be addressed. Let's get you a sense of what else we know. Bring in SABC News senior reporter Canny Maphanga, joining us live now from the Constitutional Court. And Canny, no overstating the potential jurisprudence that is likely to come out of this, but I can't imagine a scenario where you don't delve into things like culture, given just the arrangement of our society.
Indeed. Good morning to you, Ayanda, and to the viewers at home. I did lose you at the end there, but this is quite a significant matter heading to the Constitutional Court this morning. Essentially, what we are dealing with a matter that speaks to the right to gender equality in South Africa and the right to dignity. Essentially, we have four applicants, that is two married couples, that are challenging the Births and Deaths Registration Act or sections of it, insofar as it doesn't allow a woman the right to have her spouse assume her surname, or alternatively doesn't allow the male spouse to assume the surname of their wife. Of course, this is a significant matter because it does speak to this issue that we do have as a fairly young democracy, is that a lot of the legislation that we are faced with today in the country needs to meet the constitutional demands or the democratic order of the day. And the Births and Deaths Registration Act, however, is not exempt from this. So essentially what you have today is we are seeing these two married couples challenging it, and so far as they challenges in assuming the surnames of their wives in the Department of Home Affairs. So essentially what you saw, Ayanda, is that we have two couples, that is Jana Joran and Henry van der Merwe, as well as Jess Donnelly and Mr. Bornman. They experienced similar challenges at the Department of Home Affairs, which did not allow the challenges to be remedied because the system would not allow it due to the legislation that is currently in place. So what you saw was that Jana Joran, who lost her parents at a very young, tender age of 4, biological parents, wanted to keep that surname. We understand that the family did decide that the surname of Joran would be the family's surname. However, when they went to Home Affairs to give effect to this wish or desire for their family, they couldn't do so because the system did not allow it, because the provisions didn't make room for such a change. Then you have the second family, that is Jess Donnelly and Mr. Bornman. We understand that Jess Donnelly is an only child, so of course she would want to hold on to her name and keep that legacy, or keep the name going further for generations to come. And her husband wanted to hyphenate his existing surname by adding her surname on. That would be Mr. Bornman Donnelly. Essentially, that's what you would have seen. However, when they turned to Home Affairs, they couldn't make that change because the provisions do not allow it. They then successfully challenged this breach of their constitutional rights in the Free State Division of the High Court, contending that it's rooted in colonialism. It unfairly discriminates on persons on the basis of gender. There's no rationale for why this limitation exists, and it doesn't serve a legitimate government purpose. The Free State Division of the High Court agreed with the applicants and ordered that constitutional invalidity, and so far as the said act does not allow for a woman to have her husband assume her surname, or alternatively the male spouse to assume the surname of their wife. We're now in the Constitutional Court, Ayanda, because in order for that constitutional invalidity from the High Court to take effect, you will need to come to the Apex Court to get that confirmation. It is an unopposed application, so we expect that it should be smooth and that it should be an easy task for the applicants to get that confirmation, because it is an application that is premised on the rights to gender equality in South Africa, and there aren't any reasons provided as to why this limitation should exist in the constitutional democratic order. So of course that hearing will begin at 10 a.m. this morning, and SABC News will be giving you that rolling coverage as soon as it begins.
Without a doubt, Canny Maphanga, live to us there from the Constitutional Court in Braamfontein. And again, it almost feels like a completely significant shift, which is all likely going to happen. And I wonder what the cultural experts in our country have to say. But Canny, I won't give you that pressure. Once again, Canny Maphanga is in the Constitutional Court.